Dear viewers, greetings. We are not professional YouTubers. We do these videos for promotion of Guide to IBC website and as well as to tell our viewers of selected cases which we find interesting. We don't have any sophisticated tools for editing. Furthermore, we don't have any script. The videos are more impromptu in the sense that after the judgments are collected, after the judgments are assimilated, we immediately do the video. So there may be some compromise in terms of quality of the video, which I'm sure you will excuse. Secondly, I would welcome all the viewers to please comment on our video so that we know in case there are any shortcomings. With this, I'll be taking you over to the next part of the video.
Viewers, you can see Guide to IBC homepage on your screen. Guide to homepage, IBC homepage on your screen. Now let us move to a very interesting case as far as, let us discuss what it is. Let us have a little bit of suspense. Yeah. This is Dhruv Harjai versus PPG Asian Paints. Now, in this particular case, what happened was there was a motor vehicle body repair company or a workshop which took which entered into an agreement with a paint supplier. And they said that they entered into an agreement in which it said that it's going to buy 1 crore worth of product in a span of 1 year's time. Now, with that point of view, the supplier gave the corporate debtor an advance or a financial assistance of 35 lakhs. But as a security, he kept a promissory note in which the corporate debtor said that in the event that he fails to buy 1 crore worth of product in a year, then he can invoke the promissory note in which he owes 1 crore and accruing at a payable on demand with interest at the rate of 12%. Now it came up in question in court whether this is an operational debt or a financial debt. In any case, if you can see, let us go back. It has connection with material. Now, they wanted to revamp their bodybuilding shop. So the corporate debtor was of the view that this is an operational debt, whereas the operational or the creditor say that it is a financial debt. So NCLAT held that even if a debt has some connection with goods in the transaction, the provision of Section 5, subsection 21 cannot be applied as there is a commercial effect of borrowing. At the end of the day, if you look at it, the financial contribution was for the purpose of sales and promotion, whatever it may be. But the respondent made an upfront payment of rupees 35 lakhs, which was secured by the demand promissory note, upon which the CD agreed to pay 1 crore plus 12% interest. This understanding between the parties is covered by Section 5(8) of Insolvency Bankruptcy Code, and it has a commercial effect of borrowing. The contribution of the appellant, that the subject matter of the debt, that there is some connection with goods in the transaction, which would attract provision 521, could not be accepted. Now let us move on to another interesting case. We move on to Mr. Deepak Raheja versus Union of India. This case, the main highlight is assignment of debt is recognized by the court as a valid mode of transfer of right across the ambit of Section 5, subsection 7. Now, in this case, what happened was uh, Deepak Raheja, owner of JW Marriott Hotel, they had borrowed about 450 crore or something from Piramal Housing. During the period of COVID-19, there was a circular from government on 27/12/2022, and the circular also came out on 21/3/24, that NBFCs and banks should render assistance to people. But in between, they defaulted, and Piramal assigned the debt to Omkara ARC. Now, what NCLAT held was assignment of debt is recognized by the court as a valid mode of transfer of right across the ambit of Section 5, subsection 7. The requirement of law is only an intimation, no prior notice. The IBC 2016 defines default to mean non-payment of debt when whole or any part or installment of the amount of debt has become due and payable and is not paid by the debtor or corporate debtor, as the case may be. The appellant has not contested. The appellant has not contested that the principal or interest payment or any amount wholly or partially was not overdue at any point of time. So if that be so, the respondent number 4 and 6 decided to assign the account to respondent number 7, which is Omkara. Surely the facts of this case cannot be faulted. We are now coming to an interesting case of authorized representative of Granite Gate Properties Private Limited versus Devendra Singh. This case has got two aspects. One is dealing with what is CIRP cost, and another is dealing with the timeline of CIRP. Now, with regard to CIRP cost, we are aware that as per Regulation 31 of CIRP regulations, CIRP costs are defined as costs would be CIRP costs if they are directly related to the CIRP in running the business of the corporate debtor as a going concern and approved by the Committee of Creditors. Now, in this particular case, what happened was this was a real estate project and the corporate debtor had taken it from Noida at a price of 372.5 crores, of which 10% was paid, 90% was payable over a period of 8 years. Noida had allowed moratorium of 24 months and an interest was payable at the rate of 11%. And during 24 months of moratorium, only interest was payable, and the rest was supposed to be payable over a period through installments. Now, 19th and 20th installment fell due during the CIRP period. Question came as to whether this is payable, this is to be considered as a CIRP cost or not. The matter went up to Supreme Court, and Supreme Court held that yes, 19th and 20th installment payable to Noida is CIRP cost and should be paid by SRA. With regard to water and sewage charges, it was not contested at all, and it was decided that this was CIRP cost. Now, the completion time for project was supposed to be 8 years. Noida said that they were agreeable to allow 3 extensions. But for each extension charges were supposed to be paid. Now, it was 4%, 5%, and 6%. The question was whether this extension charges was to be considered as CIP cost. Now, since the company was being run as a going concern, NCLAT held that yes, these are CIP expenses. Now we come to the other part, which is the timeline. Now, this particular CIRP was of 1920. And the plan was in fact approved in 2020, but it went up to 2024. Now, NCLAT say that timeline for considering completing CIP process does not permit directing commencement of process from the stage of information memorandum, which was suggested by NCLAT. This started instead what there was problem with valuation. They also wanted uh, transaction audit being done. So what NCLAT directed that COC to issue RFRP to resolution applicants whose names were there already in the final list of resolution applicants. RS to submit resolution plan within a period of 30 days. The resolution professional should issue addendum to information memorandum to facilitate resolution applicants to submit resolution plan. The addendum to information memorandum to be issued along with the RFRP. The period during which the applications remain pending before adjudicating authority decided on 24/7/2024. That is a period of 4 years from 2020 to 2024. This period and the period for which the matter was being considered at NCLAT was to be deducted, was to be excluded from CIRP period. Still then, considering that the CIRP had ended, NCLAT further allowed an extension of 90 days to complete the CIRP process. Because at the end of the day, achieving a resolution is the objective of IBC. This is a nice and beautiful case, in my opinion. It's a 3-page judgment, but is of extreme importance. This is Girish Magadla Limbachia versus Dharmil R. Mehta, in which NCLAT, Honorable NCLAT held that when there is no debt, there is no question of initiating CIRP proceedings. If you go into the case, what happened was a financial creditor initiated proceedings under Section 7, claiming debt of 1 crore 60 lakhs, and along with interest, it was 2 crore 43 lakhs. The CD wanted, though there was nothing in writing, CD wanted to repay the entire amount. But FC refused to accept the amount without assigning any reason thereof. The adjudicating authority admitted CD to CIRP proceedings, CIRP process, under Section 7 of Insolvency Bankruptcy Code. The matter went to NCLAT, and wherein the CD was ready to pay 2 crore 62 lakhs because the interest had increased. And at NCLAT, the FC accepted the amount. So NCLAT held that since during pendency of the appeal, the financial creditor has received a total amount of 2 crore 62 lakhs, the present is not a case of initiating Section 7 proceeding against the corporate debtor. Why this case is exceptional? Because once a CIRP proceeding is initiated, it can be withdrawn under Section 12, Section 12A by executing Form FA. But herein, NCLAT exercised its jurisdiction, and because the CD had initially offered to pay the entire amount during the CIRP proceedings, so NCLAT exercised its inherent power and said that there is no CIRP proceedings possible against the corporate debtor. So this is why this case is interesting. Now we come to an interesting case which was decided by Madras High Court in KJ Vinod versus NCLT. Honorable High Court held that prima facie in all three cases, that is Section 7, Section 9, and Section 10, FC, OC, and CD's suggestion for appointment of IRP by applicants are applicable to be accepted. Applicants are liable to be accepted. What it held that it referred to Section 10 and Section 16 and held that the sections are very specific, that it only gives leeway in the case of Section 9 if OC doesn't suggest the name of IRP. Otherwise, in Section 7 and Section 10, the name of IRP is mentioned. And if no disciplinary proceeding is existing against the name of the RP, he should be appointed. And there is no second rule about it. And High Court held that they ought to be appointed. Now we go to another case which was decided by NCLAT pertaining to liquidation. The adjudicating authority, it held that adjudicating authority under Regulation 33, the adjudicating authority has the power to extend the time period specified in Regulation 33 of the Liquidation Process Regulation if it finds serious flaws in the conduct of the auction. Now we know that the period for making payment in the case of auction is 90 days. Now in this case, the 90 adjudicating authority not only allowed additional 90 days, it allowed further period of 1 month, 30 days. Because the concerned land had some, it was a class 2 category land, and it required permission from the government for making transfer. It went into into litigations and all that. Considering that there was consequent to that, there was delay in the process, and for which neither the liquidator was responsible nor the auction purchaser was responsible. So NCLAT was of the view that adjudicating authority has the power to extend the time period specified in Regulation 33 of Liquidation Process Regulation if it finds serious flaws in the conduct of the auction. It is open for the adjudicating authority to exercise its inherent power under Rule 11 to grant extension of payment as long as it is satisfied that sufficient grounds exist. In the present case, there were compelling circumstances which constrained the liquidator from securing the sale consideration of the auction land within 90 days. There is no sufficient reason to hold that the entire delay was on the making of the liquidator. No purpose would be, and most importantly, NCLAT held that no purpose would be served if the auction is set aside, and it would only result in delays and costs to be borne by the members of the SCC, which we cannot comment. Now we move to another case in which this is a Supreme Court matter, doesn't relate to Insolvency and Bankruptcy Code, but the Honorable Supreme Court held that res judicata cannot be decided merely on the assertions made in the application seeking rejection of plaint. Adjudication of plea of res judicata is beyond the scope of Order 7 of Rule 11 CPC. The issue relating to whether an ex parte decree is obtained by collusion or whether defendant number 1, as alleged, has played fraud, need to be examined in detail. Such circumstances require in-depth examination of the previous decree and its impact on the second suit. Res judicata cannot be decided merely on the assertions made in the application seeking rejection of plaint. Res judicata cannot be a matter of speculation or inference. These are all very important points. We come to another case of Supreme Court. This also doesn't relate, this was a SEBI-related matter, but this will have implication in IBC also. This was Jaykishor, Chaturvedi, etc. versus SEBI. It held that the Interest Act 1978 empowers tribunals and including SAT It held that the Interest Act 1978 empowers tribunals, including SAT, to award interest from the date of cause of action, from the date cause of action arose until the initiation of recovery proceeding based on equitable considerations. Jaykishor, Chaturvedi, etc. was the Security Exchange Board of India. So this is a very important judgment by Supreme Court in the sense that in Section 66, or we have put it in Section 67, because we often see that NCLAT is imposing penalties and costs, and the parties don't pay. It is not just the responsibility to pay the penalty and the cost, but there is an interest element also which can be charged. That should be in this case, Supreme Court uh, related this thing to Section 220 of Income Tax Act and said that period of 30 days is allowed. And beyond that, interest has to be paid as per Section 220 of Income Tax Act. So this is a very important matter which we should keep in mind. Now, why I'm showing this case of Messrs. Bafna Pharmaceuticals Limited versus Assistant Commissioner Provident Fund. This is a case pertaining to a resolution plan being approved and then thereafter Provident Fund lodging a claim. Now, normally you will definitely expect us to talk about Ghanshyam Mishra, Section 31, because post approval of resolution plan, no claim can be lodged against the company. But instead, this case is featuring in Section 231, which deals with bar of jurisdiction. Now, in this particular case, Honorable High Court held that an unjustified interference with the proceedings initiated under the Insolvency and Bankruptcy Code 2016 breaches the discipline of law. Honorable High Court went into the matter. They asked the claimant, that is the Provident Fund Authority, as to why they had not approached NCLT or NCLAT, which has specialized adjudicatory mechanism, and instead had come to High Court, and they held that this is a High Court should automatically show restraint, and held that this is an unjustified interference with the proceedings initiated under Insolvency Bankruptcy Code. And this would constitute breach of discipline of law. Now let us move to another case wherein this is pertaining to Section 238A, wherein the Honorable NCLAT held that the claim filed is belated claim and it is barred by Limitation Act 1963. In this particular case, this was a voluntary liquidation matter in which the liquidator had submitted application for dissolution of the company under subsection 7 of section 59 of the code. At that point of time, an operational creditor applied for intervention pertaining to an invoice which was raised in 2015. And the first interaction took place sometime in 2016. They had lodged, and corporate debtor had objected. They had filed Section 9 also, which was also rejected. So what the court held was no claim was filed. And most importantly, the claimant did not file any claim. Claimant did not file any claim, proof of claim. What they did was an intervention petition. So the court held that no claim was filed by the respondent before the liquidator, nor proof of claim was filed. Rather, application for intervention for the purpose of raising the claim was filed for the first time in 28/8/2019. If the limitation period is counted from 18/9/2025, that is the date of the invoice, the limitation would end on 18/7, 17/7, 17/8, 17/9/2018. And if it is counted from 18/7/2016, it would also expire on 17/7/2019. So this case was brought by Limitation Act 1963. So with this, we take you over to the next part of the video.
Viewers, we have come to the end of our podcast. I hope you have enjoyed. We have tried to select some very interesting judgments, and I hope you will enjoy the judgments. And please go through the judgments in the website so that you can get in-depth knowledge. Thank you. Bye for now.